So students, in this video, we will discuss about the two legal systems. They are adversarial system and inquisitorial system. We will. So there are mainly two types of recognized legal system in the world. They are one is adversarial system and the second one is inquisitorial system. And these systems are mainly differs in the aspects like the way of approach they taken to resolve the disputes and how do they gather evidence and how do they conduct trials. On these three aspects, these systems are different with each other. So first we will discuss about the adversarial system, and let's see how its historical development happened. So we can say that this adversarial system is deeply rooted with ancient English common law, and it further developed during medieval period, and by the end of uh, 18th century it became the central part of English and American law. And the main features of this system is that it mainly designed to protect the individual liberties, and it ensure a fair trial to the accused, and both the parties will be properly represented before the court, and the accused also will get a privilege of presumption of innocence. So this adversarial system is also known as accusatorial system, and in this system there will be mainly two parties with which opposing each other, and the prosecution will represent the state or the victim, and the opposite side the defense counsel will represent the accused. And here in this adversarial system, the role of the judge is, we can say that it quite passive and neutral, and the judge will act as an umpire, and the judge will ensure that the parties are following the legal rules and procedures. And in this adversarial system, how the proceedings develop is like the parties will develop their own story or their own theory of the case, and they will collect evidence to support their claims. In this, the main highlight of this adversarial system is that here in this system, the lawyers are playing the active role. The lawyers will gather evidence, they will conduct cross-examination of both the victim and the accused, and even scrutinize the evidence produced by the opposite parties. And now we will see in which all countries this adversarial system is following. This system is basically following by the countries which are following the common law. We can say the example is, of course, it's India, US, UK, and Australia, and there are many. And so, what is common law? Common law means it's a legal framework where the judges will decide the cases based on previous judgment. There will be precedents proclaimed by the higher courts. So the judge will decide a case based on the previous judgments. Normally, these precedents will be established by higher courts, and the lower courts will follow the same judgment if the facts are almost similar. So we can say that in this system, the judges will decide the case solely based on the evidences and arguments produced by the parties before the judge, by their lawyers. Now we will discuss about the advantages of this adversarial system. And the supporters of the systems argued that it is fairer and less prone to abuse, and there will not be any room for the state to favor the defendant. And since it highlighting the principle of presumption of innocence, to some extent it safeguards the interest of the accused. And here under this system, the defense attorney can even scrutinize the evidence produced by the prosecution and can cross-examine the victim and victim supporting witnesses. And moreover, the accused has the privilege against self-incrimination. Self-incrimination means he or she is not supposed to make statement against himself or herself. So it's absolutely based on the skillful legal representation by the lawyers that the success or the failure of the litigation is dependent. Now it's a time to check the disadvantages of this legal system named adversarial system. So the main disadvantages is the cost of the litigation basically falls under the parties. So we can say that the system is bit expensive and time consuming. And there arises a problem that the parties with good resources can access justice easily by hiring competent lawyers. Here in this system, we already learned that the role of the judge is very passive. So he can only evaluate the matters or the evidence produced before him. So if the parties recruit a skilled lawyer, these skilled lawyers can use loopholes or technicalities to create doubt in the mind of the jury. So students, now we will move to the second legal system, that is inquisitorial system. First we will check its historical development. So here we can say that this legal system originated in continental Europe. It mainly follows the Roman law and the procedures followed by the Catholic Church. It's after French Revolution, a refined version of this inquisitorial system developed in France, and this system is making justice more efficient and reducing the influence of powerful lawyer. Here in this system, it's not the lawyers, it's the jury plays the key role. So under this inquisitorial system, it is the judge or the jury plays the crucial role. It is a judge who determines the facts and issues of a disputed matter before him, and even the judge determines the way how the evidence need to be presented before the court. Like, see, sometimes he demand the evidence need to be produced orally. Sometimes he suggests for documentary evidence. So sometimes he demand both form, like oral evidence and documentary evidence. And the judge is playing the investigating officer's role. We already discussed that he is the person who is collecting the evidence. So he plays the role of an investigating officer. And here, like in adversarial system, the process of cross-examination has no much significance under this inquisitorial system. Sometimes the judge may examine the parties, but the judge examines the witnesses directly. Accused will get a chance for legal representation, but he cannot make any statements or is not allowed to speak. And if he produced any evidence, that would not be under oath. And this inquisitorial system is mainly following in countries which follows civil law. And we can say example like countries Germany, France and China and many more are following this inquisitorial system. But in Germany, under this inquisitorial system, the investigation will be done by both the judges and prosecutor together. While in France, the prosecutors are not allowed to make um, uh, the prosecutors will not allow to work together with the judge. They are allowed only to make a recommendation after the investigation is over. And under this inquisitorial system, um, the prosecutor will propose a trial only if there is adequate evidence to prove that accused is guilty. And now let's see what are the advantages. So we can say that this inquisitorial system is much speedier and less expensive. And yes, of course, there will be equality between the parties because here there is no chance that the stronger party can recruit any expert lawyer and collect more resources and by the end influence the judge. So we can say that there will be no bias in justice under this system. Everyone will be integrated or asked questions in the same way. Um, either side will not get any preferential treatment. So, what are the disadvantages? Yes, it's crystal clear that a single individual, that is jury, he is the one who determines the final judgment. And what happened in most of the case, the final decision was already been made by the judge even before the trial starts. And because he is the person who is collecting the evidence and doing the investigation, all these process. Um, Moreover, since the judge steps into the shoes of an investigator, as we discussed, he can no longer be remain neutral, um, since he plays the role of an investigator.